Appeal for judgment, Rummun versus the State of Mauritius.
Lord Kerr will give the judgment to the board.
Following a trial before a magistrate in the Intermediate Court of Mauritius, Hassen N. Rummun was found guilty on the 9th of October 2009 of the offence of larceny while armed with an offensive weapon. The following month, November 2009, he was sentenced to 4 years penal servitude. The offence of which Rummun had been convicted had taken place almost 10 years earlier, on the 13th of December 1999. He had been arrested on the 2nd of February 2000 with 3 others. All had confessed to their involvement in the offence on that date. Despite this, the accused did not appear in court until July 2002, and his trial did not take place until September 2009. On the 21st of September 2011, the Supreme Court of Mauritius dismissed the appellant's appeal against the sentence that had been imposed by the magistrate. Section 10(1) of the Constitution of Mauritius guarantees a fair trial within a reasonable time to all those charged with criminal offences. Unfortunately, neither the magistrate nor the Supreme Court addressed the question of the breach of the appellant's constitutional right to a trial within a reasonable time, despite the inordinate delay in bringing the proceedings against him to a conclusion. The board considers that the right to a prompt trial is a fundamentally important constitutional guarantee. Magistrates and judges should be astute to detect delay in the conduct of criminal trials and should be proactive in seeking to eliminate it. The magistrate in this case, therefore, ought to have addressed the question of delay in the context of the constitutional guarantee, and she should have examined the individual responsibility of each of the defendants for that delay. Instead, she summarily dismissed the relevance of this factor by saying that the delay was largely attributable to the defence. Likewise, the matter ought to have been directly addressed by the Supreme Court. It should have considered whether a declaration ought to be made that the appellant's Section 10(1) rights had been breached. It has now been accepted that the delay in this case constituted a breach of the appellant's constitutional right. The board considers that the necessary close examination of the reasons for the clearly immoderate delay in this case is best conducted by the Supreme Court of Mauritius. That court is better placed to assess how the seriousness of the offence of which the appellant has been convicted should rank as a factor against the now admitted breach of his Section 10(1) right. That court will also be familiar with such sentencing guidelines as exist to point to the range of sentence that would have been appropriate if there had not been delay, and how much, if at all, that range should be adjusted to reflect the violation of the appellant's constitutional right to a trial within a reasonable time. The board therefore remits this case to the Supreme Court of Mauritius to consider the sentence to be passed on the appellant in light of the guidance provided by the board's judgment and its examination of the factors which the board has outlined should now be considered. It is to be hoped that the reconsideration of the appellant's case can be conducted with all due expedition. The parties will have 28 days within which to make written submissions on costs.